Welcome everyone. This is the 6th week of the Florida Bar Crash Course. And today is a very, very important day because we're starting multiple choice. We spent a lot of time in the past reiterating essays and coming up with good formulas for every essay, for contracts, for torts, for con law, federal and Florida, and for real property. And then last week we had Will to teach us about family law and trust. And I love putting people on the spot, but this is like voluntarily. Does anyone remember what is necessary to create a private trust in Florida?
Yeah, you need a settlor with intent and capacity. So capacity and intent to create. You need a trustee with duties. You need trust raise and delivery of that trust raise, the trust assets. Trustee with duties, ascertainable beneficiaries, and you need a valid purpose, which is any legal purpose or something that's not against public policy.
Love that. And in a few weeks, I'm gonna ask someone to do the elements of negotiability for commercial paper, but Joe, I know you already got that down. I'm very much a believer in memorizing the key points to the essays that you know are gonna be tested. That was awesome with the elements of the trust, and you wanna know the duties of the trustee and spendthrift provisions, who can pierce them. Those are some important points. With the family law that we did last week, does anyone remember the different types of alimony in Florida? You don't have to answer, Joel, but I like the confidence in the head shake. Does anyone else know?
PBR, divorce party.
Let's hear what that means.
Temporary alimony, bridge to gap, rehabilitative, durational, and permanent.
Excellent. Let's make sure we all have things like that memorized, because that's the key to performing well in essays, is having the precise rules of law memorized. So when you identify the issues, you can get all of the points necessary for that issue. And we're going to come back to essays, not next weekend. Next weekend we'll do business entities and wills, but the following weekend we'll do secure transactions, commercial paper, and ethics. And we'll talk a lot about essays. But for this week and next week, we're gonna shift gears to Florida multiple choice. And I have to say that Florida multiple choice is known in the bar community as probably the most difficult part of any bar exam in the country. I've taken California. It's hard, the essays, but there's nothing comparable to Florida multiple choice. It's its own beast, right? And those who are here today or who are watching this recording get the ultimate pleasure of first getting the highlights of these 3 important issues from Stephanie McKenna. She's going to teach us about Florida civil procedure, Florida criminal procedure, and Florida evidence. And as I've already introduced to the class, she just passed the bar in July. Material's fresh in her mind. She's an amazing instructor for us, and we're excited. So I'm going to make you the host, Stephanie, so that you can share screen.
Perfect, thank you.
And the floor is all yours.
Okay, are you able to see my PowerPoint? Okay, so yes, as Andrew mentioned, the Florida multiple choice definitely is its own beast, as probably most of you have also experienced. In my experience, I think it's a little bit different than the MB multiple choice questions, right? It's not as sophisticated. You're not going to get paragraphs of situations or things that could happen, maybe where you can start noticing patterns or things like that. I think more so it's really just rote memorization. You have to memorize the rules. You have to memorize the little exceptions, the dates, the deadlines, things like that. So that's mainly what I'm going to be going over today, to just give you guys a brief overview, like Andrew mentioned, and then he's going to delve deeper into each of the topics. So first, we're going to go ahead with Florida criminal procedure. I wanted to discuss some things that can be filed or can be sort of performed prior to trial in terms of timing. So you will get a lot of questions on when things can be filed or when they can occur. So I've sort of structured things in with that in mind, in terms of whether things are occurring before trial, during trial, after trial. So first we have the first appearance, which, as it's named, is going to be the first time the defendant is going to appear before the court. So the purpose is to inform the defendant of the charges, in which they're going to be provided a copy of those charges, and to advise the defendant of their rights. So attorneys must be given notice of hearing and attend the first appearance. Usually, if the person has a private attorney, that will be something that'll be coordinated prior. If they don't have a private attorney, a public defender will be assigned to them at the first appearance. Or of course, if they choose to, represent themselves, they'll sort of make note of that at the first appearance. So that has to sort of take place within 24 hours in which they've been arrested. They have the right to see a judicial officer within 24 hours of being arrested or to be released. Release on your own recognizance. There's two different methods in which someone can be released on their own recognizance. First, if they're charged with a capital offense or a life sentence, and the proof of guilt is evident or presumption of that guilt is great. There's a second option in which no conditions of release can assure the defendant's appearance, community safety, or judicial integrity. So those are sort of situations in which the person is not going to be released on their own recognizance. You want to look for those factors if they're asking a sort of question about that. If it's to do with the capital offense, obviously you'll look to sort of those first factors. If not, you're going to look to whether they might pose a danger to the community. So if they are in pretrial release and they have significant restraints on their liberty, they can request a probable cause determination within 21 days. Some significant restraints could be, you're confined to your home, you're confined to the certain area, they can't leave certain areas. So that's when they would be able to request that probable cause determination. And if they do request that, the court must make the determination within 7 days. Now, I know I'm going sort of at a fast pace. Does anyone have any questions about those first two elements before we go into anything else?
Does anyone have any questions? No, so far so good.
Okay. All right, so then we're moving on to the non-adversary probable cause determination. As it's titled, it's not going to be sort of a trial or an evidentiary hearing. It's just going to be a determination of probable cause. So that has to be made within 48 hours. Usually, there's going to be probable cause if there was probable cause to arrest the defendant. They're probably not going to ask you about that because it's more so of a substantive than procedure issue. But that must be made within 48 hours. The state can obtain 2 24-hour extensions for good cause. So keep that in mind. Then moving on to the adversary preliminary hearing. So that will be where both sides can sort of argue and present their own sort of evidence. And the purpose of that would be to determine if there was probable cause to support felony charges and to continue to detain the individual. In that hearing, witnesses would be able to be summoned and examined, sort of like it's not a trial, but a mini evidentiary hearing. If the defendant has not been charged with a crime within 21 days, if they're a felony defendant, that's when they would have the right to an adversarial preliminary hearing. In terms of release, obviously a court will not allow a state to keep the defendant in custody indefinitely if they haven't been filed formal charges against them. If the defendant is in custody, the state has 30 days from arrest to charge them with a crime. If they haven't filed charges on the 30th day, then the court must release the defendant by the 33rd day. Of course, if the state has some sort of good cause for delay, the period can be extended up to 40 days. So again, keep all of these numbers in mind. Release can also be revoked if the state provides good cause within 3 hours of notice. So let's say the defendant was given notice that they were going to be released, and then something else comes up that sort of amounts to that threshold of good cause, and they're provided that within 3 hours before they're released, they would be able to revoke the release in that case. All right, moving on to the motion to dismiss. That can be filed after the arraignment, and it can be filed on a few different factors. So the first being if they were granted immunity for that crime with which they're being charged. If there are no facts in dispute, which is similar to other types of motions that we'll get into shortly, and if the person is being subject to double jeopardy for the crime or they've already been pardoned for the crime. So that needs to be filed before or at arraignment. For those that may not know, arraignment is sort of when the defendant will show up, they'll make their plea of guilty, not guilty, no contest. So if they're also going to assert any sort of these motion to dismiss issues, they would have to assert that before or at the arraignment. Then speedy trial, I do see a good amount of questions in regards to this. So the defendant can file a demand for speedy trial anytime after the formal charges are filed. That basically signifies that they're available and prepared for trial within 5 days. At that point, after that is filed, the state has 50 days from the defendant requesting the speedy trial to bring the defendant to trial. If there is no demand for the speedy trial, it must take place within 90 days from arrest. For a misdemeanor, for a felony, it's going to be 175 days from arrest. For a retrial, it's going to be 90 days. So those days are sort of in the case that the defendant doesn't demand a speedy trial, and then those 50 days aren't triggered, right? So if the state fails to meet those deadlines, the defendant can then file a notice of expiration of the deadlines, and the court must hold a hearing on that motion within 5 days. So if the state does not show good cause for delay, the defendant must be tried within 10 days. So sort of here you see it's a total of 65 days after they file that speedy trial demand. After the 65 days, they're going to have to be released if there isn't sort of good cause, if the hearing isn't held on the motion. So that's maybe the overall number you want to look at. In terms of insanity, that must be filed within 15 days of arraignment. So again, something that needs to occur prior to the trial. That's an affirmative defense that's going to be raised. The burden is clear and convincing evidence to assert the insanity defense. Similarly, with incompetency, that can sort of be raised at any time at which it comes up. I put it in the section of before trial. It might even come up during trial that someone might be deemed to be incompetent. Basically, the standard for that is that the defendant cannot understand the nature of the trial proceedings that are going on. So logically, they can't be tried or punished for the crimes that they're being accused of. So the time for that, in terms of misdemeanors, if a defendant is held to be incompetent for a consecutive period of 1 year, then their charges are going to be dismissed without prejudice, which means they can be refiled if later they regain that competency. In terms of felonies, it's going to be 5 years. As you can see, the condition has to be renewed and reviewed every year. So it needs to be a consecutive period of time. And the court can order an examination by up to 3 experts. So each expert, up to 3, whether it's 1 or 2, would be able to review that status of competency and determine every single year whether that person is still incompetent and can't be brought to trial. If it's at 5 years, it's going to be dismissed without prejudice for felonies, 1 year for the misdemeanors. Okay, does anyone have any questions about the things that that sort of may occur or must occur prior to trial?
We had a question. Is it possible to view this in slideshow mode so it's a little bit more?
Oh yes, sorry. I had tried doing that. Let me see.
No, you're good. It's a Zoom thing. Yeah, you're
Okay,
good.
does it work like that?
It's working. Yeah.
Okay.
Yeah. Thank you for that. So if you go to the next slide that you were on, I just have to say, I really appreciate you. Your introductory slide was all numbers and facts, but very important. They test these things straight up, especially 90 days for misdemeanors, 175 for felonies, the 24-hour release, and then the fact that the state may obtain 2 24-hour extensions for good cause. All these things can definitely be tested, but not the most riveting slide, but an important slide. So yeah, let's keep it moving. Good start.
Thank you. Yeah, like Andrew said, I guess procedure is definitely not the most interesting topics, right? Especially compared to the MBE. But I did want to highlight sort of the dates and when things need to take place, because that's a lot of what they ask. And like I said, it's just a matter of memorizing the law, especially in terms of the procedure. Okay, so then we have sort of things that can occur during or after the trial. A motion for judgment of acquittal. It's similar to the maybe civil version of a motion for summary judgment or motion for directed verdict, except only a defendant can move for the motion for judgment of acquittal. Basically, the standard for that is that the judge determines that no reasonable jury could return a verdict in favor of the state. It cannot be appealed when there is insufficient facts to prove the defendant's guilt. So during trial, you can move for a motion for judgment of acquittal at the close of the evidence of the state's case. And post-trial, it can be filed 10 days after a guilty verdict is determined or after a mistrial. Motion in arrest of judgment is a fatal procedural defect in trial. The verdict cannot stand. It's usually used if